My name is David Richardson, and I'm a litigator and bankruptcy attorney at SulmeyerKupetz. The topic I'll be speaking about this morning is removal of litigation to the Bankruptcy Court and why that might often be a strategy that's in the best interests of the non-debtor parties to the litigation. A typical scenario where litigation is removed to Bankruptcy Court involves a defendant who expects to lose a trial, who files a bankruptcy on the eve of trial as a delay tactic, and then removes the case to Bankruptcy Court in an effort to gain leverage, or at least the perception of a home court advantage. The non-debtor party typically immediately files a motion for remand of the litigation and a motion for relief from the automatic stay to allow the trial to go ahead because they prefer a state court forum, they have a judge who is educated about the case, or many other reasons that might seem to favor remand. What I want to address this morning are situations where bankruptcy jurisdiction may work to your advantage, and some of the issues you should consider when making the decision whether or not to remove the action to Bankruptcy Court or whether to contest the debtor's removal and seek remand. The decision to not remove litigation to Bankruptcy Court or to seek remand after the debtor removes it is often an almost automatic response, but there are many tactical issues that should be considered before the decision is made. Sometimes a defendant files bankruptcy early in the litigation, or the defendant has engaged in fraudulent practices that may reach far beyond your litigation. Assets you hope to reach are being dissipated, or the defendant has even been arrested for that conduct. You may have a strong case for summary judgment, or you may even be the defendant to frivolous litigation or cross-claims. These are some examples of situations where the non-debtor parties to litigation might be better off keeping the case in Bankruptcy Court or even removing the case to themselves if the debtor doesn't remove it. There are 6 topics I plan to cover this morning: timing and scheduling, differences in judges and the myth of the home court advantage, some jury trial considerations, the expense or savings of bankruptcy, subpoena and witness issues, and finally, if you're going to remove, the deadlines that you need to know about. First, on timing and scheduling. One of the primary reasons you might want to consider the forum of Bankruptcy Court is scheduling, especially if you think you have a strong case for summary judgment. The eventual trial date you might obtain in state court or Bankruptcy Court might be quite similar in either court, especially if it's driven by the party's schedule for discovery. But for motion practice, Bankruptcy Court offers a relatively reliable and prompt process for obtaining hearing dates. Anyone practicing in state court these days likely has their own lengthy list of war stories about the scheduling problems caused by widespread budget cuts. At a CMC I attended recently, the court set the trial for only 13 months away, but informed the parties that if they thought they might want to file a summary judgment motion, then they better secure the hearing date immediately because the next available hearing date was 12 months away. I scheduled a demur a few days ago in another case for a hearing date that's 3 months away, and I was quite pleased to get the date that quickly. But in most cases, hearing dates in Bankruptcy Court are widely available online at a time close to the service requirements. An ordinary motion requires service 21 days prior to the hearing date, and with most courts, you can typically find a hearing date that's available within a month of when you start drafting your papers. Most judges have 1 or 2 hearings each week on issues that arise in litigation, or adversary proceedings as they're called in bankruptcy. Summary judgment motions require 6 weeks' notice. If you anticipate more than 15 minutes of argument, you may need to clear the hearing date with the judge's clerk, and a judge's calendar might limit summary judgment motions to a few particular hearing dates each month. But typically, if you clear a hearing date with the judge's clerk as you start working on your motion, you can be certain that you'll have a hearing date that's 6 weeks from the date you eventually file and serve the motion. Similarly, a motion to dismiss can be filed in Bankruptcy Court on 21 days' notice, unlike the 3-month delay I'm facing on that demur right now in state court. So if you have a strong case for summary judgment or even dismissal, and you want to keep costs down, Bankruptcy Court may offer you a much faster opportunity to have those motions heard. Another difference in motion practices between the two is the ex parte process of state court versus the emergency motion process of federal courts and bankruptcy courts. The state court procedure for ex parte motions doesn't exist in Bankruptcy Court. Instead, you have either an emergency motion that you file if you're requesting a hearing on less than 48 hours notice, or the request for a hearing on shortened notice if you can't wait 3 weeks for a regular hearing date, but it's not a 48-hour emergency. In each case, you make the request for a prompt hearing in writing, and the court either grants or denies the request on the papers. Depending on which process you choose, it's either a declaration explaining the relief requested or the motion itself. And the court then schedules the hearing. If you think that having the ability to rush into court overnight is important to your case, you might prefer state court. Personally, I find the bankruptcy process for a hearing on shortened notice or an emergency hearing to be far preferable. Few motions ever need to be heard on less than 24 hours notice. And in state court, the judge is usually forced to review the ex parte papers minutes before a ruling. I've rarely come away from an ex parte hearing with a feeling that I had a proper opportunity to present oral argument, if any opportunity at all. But in bankruptcy court, the judge reads the papers, or at least a declaration outlining the requested relief, before even deciding when or whether to set the hearing. Simply because of the process, and not a slight to the state court judges, you're more likely to face a judge in bankruptcy court on an emergency or shortened time hearing who's had the time to read and consider your arguments before the hearing and are more likely to get a true opportunity for meaningful oral arguments. Third scheduling issue is the trial dates itself. It's a difference that's probably minor, but it may affect your decision if you prefer to handle your trial in a particular manner. Bankruptcy court schedules are not as amenable to large blocks of trial time as state courts. If you're planning on a 3-week trial, it might be held over 3 consecutive weeks in state court, but it might be spread out over 2 months or more in bankruptcy court. That might be a disadvantage depending on how you like to run a trial. On the other hand, you might get more sleep between the first and last days of trial if it's held over 2 months in bankruptcy court. The fourth issue is delays that can be caused by remand and relief from the automatic stay. Every claim that is against the debtor is automatically stayed when the debtor files bankruptcy, and you must get an order from the bankruptcy court lifting that stay before litigation can proceed, regardless of whether your litigation will be going forward in state court or in the bankruptcy court. Depending on the circumstances of your case, you might get relief from stay very quickly, and even on an emergency basis if you can show that the debtor filed its bankruptcy case in bad faith on the eve of trial. Or it can sometimes take months to get relief from stay, as bankruptcy courts generally give a new debtor some breathing room to get their case organized. But once you get relief from stay, the debtor might appeal that order. As long as the debtor doesn't get a stay pending appeal, your litigation can proceed. And though it's difficult for a debtor to get a stay pending appeal for a relief from stay order, it isn't impossible. And if the debtor does get a stay pending appeal, it might stall your litigation for years. But again, there's a low risk of that happening, and it could happen regardless of whether your action has been removed. But I raise that issue because motions for relief from the automatic stay are usually filed as companion motions to a motion that seeks remand of removed litigation back to state court. The standards are similar, and if your debtor has removed litigation on the eve of trial or other similar circumstances, you might get remand of the case very quickly. If not, remand might be a fight that can take several months. The debtor also has a right to appeal an order remanding litigation back to state court, but only to one level of appeal, either the district court or bankruptcy appellate panel. Again, the risk that a debtor will be able to get a stay pending appeal of a remand order is very minor, but it isn't non-existent and should be one of the issues that's considered when making the decision whether to seek remand. A bankruptcy attorney could help you analyze the risks that you might face depending on the case that you'd be presenting for remand. For example, if you're seeking remand because the case was removed a few days before trial, I think it's fair to say that there is an extremely low risk that a bankruptcy court would grant a stay of that order pending appeal. On the other hand, if you seek remand by arguing that the bankruptcy court lacks jurisdiction over the claims at issue, and the question of the court's jurisdiction is somewhat unsettled, there's a better chance that a remand order might get stayed pending appeal. And finally, I want to touch on the issue of the debtor's re-emerging right to remove litigation and how it can affect substantive rights of your client if you're not paying attention. If you choose not to remove your litigation to bankruptcy court, and the debtor also does not remove the litigation to bankruptcy court, this does not mean that you're done with removal or remand. If you move for relief from the automatic stay so that your litigation can proceed in state court and the bankruptcy court grants it, the debtor has an automatic right under Federal Bankruptcy Rule 9027 to remove the action to bankruptcy court up to 30 days after entry of that order. That right applies whether you're able to get relief from stay within a few weeks of the petition date or whether it took many months to convince the court to lift the stay. Some debtors who are focusing on delay might wait to remove the litigation until relief from stay is granted. When they do, a court will often promptly remand, but the debtor's action can do far more than just add a few weeks or months to delay. For example, if your goal was to get relief from stay in time to keep a rapidly approaching trial date, you need to be aware that it may not be as successful as you might think it could be just getting an order for relief from stay. Even if you manage to get relief from stay 2 months before the trial date, the debtor can add another 2 months or so of delay by removing the lawsuit on the 29th day, forcing you to then move for remand, which is likely to take up to a month, unless you're able to get an emergency or shortened time hearing on the motion. So as a consolation, however, if the court decides that the debtor's removal was improper, you might be able to recover your attorney's fees for seeking remand under 28 U.S.C. 1147C, but the debtor may have successfully added another 2 months or more of delay and may have gotten a state court trial date taken off calendar, which these days could mean a substantial delay. If you're determined to keep the action in state court, then the delay of several months involved in getting relief from stay and getting remand might all be worth it. But if you're on the fence about which court you want to have hear the litigation, you might be able to limit the ability of the debtor to delay the litigation by promptly removing the action yourself and seeking immediate relief from stay to permit the action to proceed in bankruptcy court, or not contesting the debtor's removal. The second topic I want to cover is the difference in judges and the myth of the home court advantage. Non-debtor parties to litigation often want to have a removed action remanded to state court because there's a fear that the debtor will enjoy a home court advantage in bankruptcy court, or a fear that your case will be in front of a new judge who knows nothing about the case. But depending on the circumstances, neither might be true. First, and there's a risk here of overgeneralizing or sounding like I'm critical of state court judges, but this is a process argument, not an argument about the judges themselves. A state court judge might not see anything about your case from the first case management conference until the final pretrial, or at most might see a discovery dispute. A state court judge might not see your opponent in person until the day they testify at trial, if they even testify at all. There's often the risk that your case will get referred out to another department on the day of trial, and you'll face a new judge who knows nothing about your case. A bankruptcy judge, on the other hand, has many opportunities to become very familiar with not just your case, but especially with your opponent, because the debtor's entire life is on view in the main bankruptcy proceedings, allowing that same judge to become intimately familiar with your opponent's financial situation, litigation history, and integrity. For example, if your opponent is engaged in fraudulent or questionable activities, not merely with respect to your client, but has a pattern of engaging in shady dealings, it's likely that the bankruptcy judge will become very aware of that history. There might be a motion brought for the appointment of a trustee or examiner if the U.S. Trustee's Office isn't comfortable with the state of the debtor's books or their financial management. There might be other similar lawsuits pending against the debtor brought by other parties. In state court, those lawsuits might all be in front of different judges. But if they've been removed to bankruptcy court, they're all in front of the same judge. And even if not removed, the bankruptcy judge will be aware of the existence of all of them. In the main bankruptcy case, there might be motions filed asking for an examination of the debtor to uncover hidden assets or compel turnover of assets that aren't the debtor's property, or any number of motions or proceedings that might put the debtor in an unflattering light in front of the judge. The debtor might fight those motions or refuse to comply with the court's orders. A bankruptcy judge has likely seen thousands of debtors pass through their courtroom and will have many opportunities to make a judgment about the debtor's integrity long before your trial begins. Unlike the state court judge, you might only know your opponent as the name in the pleadings until the day they take the stand. I've had cases removed to bankruptcy court where the debtor was in jail, sometimes on charges that demonstrated a history of fraudulent behavior, and throughout the case, the judge was repeatedly reminded of the debtor's past practices in multiple proceedings before our own litigation even went forward. The concept of the home court advantage is often a myth that the debtor buys into, and is often the reason that the debtor files the bankruptcy case in the first place, as a means to get away from a state court that hasn't been a favorable forum. But it often backfires. I had a case a few years ago where a defendant who controlled a family trust had been sanctioned multiple times by the state court and chose to file an improper bankruptcy petition, hoping to escape the state court judge's contempt orders and get a home court advantage in a new court. Not only did the litigation get removed to bankruptcy court, but the proceedings that followed over the propriety of a family trust in bankruptcy, over questions of the appointment of a trustee, motions to remand the litigation and dismiss the case, gave the bankruptcy judge frequent opportunities to learn all about the debtor's activities, and the home court became a very distinct disadvantage for the debtor and a very distinct advantage for us that led to substantial sanctions awards in favor of our client. Bankruptcy judges have a seasoned ability to recognize BS from debtors and they have far more opportunities to form that judgment before your litigation proceeds. And again, at risk of sounding like I'm overgeneralizing, bankruptcy judges tend to have more financially focused experience because of the nature of the cases before them and their backgrounds as attorneys before being appointed to the bench. There's often a perception that a bankruptcy judge only knows how to interpret a particular federal statute, but that's far from the case. When a debtor comes into bankruptcy, every legal issue they are facing can come into the case, and litigation and motion practice in bankruptcy regularly involves the interpretation of state law. But the focus of most of the proceedings they face every day is on the financial ability of a debtor to restructure their debts, which requires a bankruptcy judge to be comfortable analyzing and understanding financial records and concepts. Most bankruptcy judges practiced in the world of bankruptcy law or commercial transactions before their appointment to the bench. So even a new appointee is probably comfortable reading through complicated financial records. On the other hand, a bankruptcy judge might be less comfortable with a matter of family law or tort claims, and those types of cases are far more at risk of remand. But if your case involves commercial transactions, fraud, or review of complex financial records, the forum of bankruptcy court might not only provide you with a judge who deals primarily with such matters, but is also educated about the debtor's entire financial circumstances and practices from the issues that arise in the main bankruptcy case. One final issue on judges. If you've already used up your peremptory challenge to your state court judge or passed the deadline, or if you were simply concerned that luck of the draw might work against you in state court if you challenged your judge, removal to bankruptcy court presents a new opportunity. Unlike a state court transfer, you know in advance of removal who your bankruptcy judge will be. Bankruptcy judges issue published opinions, and you can research your potential judge's rulings on issues that might cover those that are similar to what's at issue in your litigation. In short, removal can provide you with a form of peremptory challenge when you no longer have the right in state court, with full awareness over who your new judge might be. The next issue that I want to cover is some jury trial issues. In particular, overcoming a waiver of the right to a jury trial. If the pleadings were finalized in state court, and if your defendant does not appear to have preserved their right to a jury trial in state court, and you don't want a jury trial, there may be advantages for removing the case to federal court to protect that waiver. Since CCP Section 631 was amended to require earlier payment of jury fees, the risk of waiver of the right to jury trial has increased substantially in state courts. And though bankruptcy court doesn't have the same issue where the non-payment of jury fees can serve as a waiver, it has its own requirement that the right to a jury trial must be asserted in a timely manner in the pleadings. If the right to a jury trial appears to have been waived in state court, CCP Section 631 permits the court to exercise its discretion to allow a trial by jury even though it's been waived. There's published authority that says wherever there's any doubt concerning whether there should be a waiver, it should be resolved in favor of granting a jury trial. The standard in the Ninth Circuit, however, is quite the opposite. In the Ninth Circuit, a waiver of the right to jury trial must be denied unless there is some cause beyond mere inadvertence or oversight. There are many cases published by the Ninth Circuit in recent years that make it very clear that it must be denied, using that language, unless the cause is beyond mere inadvertence. So if your opponent appears to have waived the right to a trial by jury in state court, you may have better luck enforcing that waiver if the case is removed to bankruptcy court. On the other hand, if you're the party to state court litigation who might not have preserved your right to a jury trial, and you're hoping to convince the court to exercise discretion and permit a trial by jury, ignore everything I've just said and do everything you can to keep the case in state court. The next issue I want to cover is the expense, or at least the perception of expense, that a bankruptcy case adds. Non-debtor parties to litigation will often try to avoid litigating their case in bankruptcy court because of a perception of increased cost. But I don't think that's an accurate concern, even though you will usually need to engage bankruptcy counsel, since most of that expense is necessary in the bankruptcy case to preserve your claim, regardless of which court actually hears the underlying litigation. The filing of a bankruptcy case creates a new front for litigation that adds a new layer of expenses that can't be avoided unless your client intends to simply walk away from their claim or quickly settle for pennies on the dollar. But it doesn't necessarily mean that having your litigation removed to bankruptcy court will also increase the overall expenses. First, unless you're prepared to abandon your litigation, you need to protect your claim in the bankruptcy case. If you're pursuing claims against the defendant for the recovery of money or property, then you need to file a proof of claim before the claims bar date set in the case, unless the debtor has already scheduled your claim in the full amount as an uncontested debt, which is unlikely to ever happen if you're already in litigation over the claim. Though creditors will often file proofs of claim without engaging a bankruptcy attorney, there are several reasons why this might not be a good idea. One of those reasons is that if there's an objection filed to your claim by the debtor, or perhaps by a trustee, there will be very limited time to file an opposition, perhaps only a week. The claim objection may involve complex issues of bankruptcy law, and by the time you locate and retain a bankruptcy attorney to respond to the objection, you may have only a few days left to educate the attorney and get a well-written objection on file. But if you'd already retained a bankruptcy attorney to assist with the proof of claim and to prepare that claim with an anticipation for the issues that might arise in a future claim objection, you already have someone who is prepared to respond and will have been served with the claim objection electronically on the day it was filed. Moreover, a well-prepared proof of claim might avoid the expense of a claim objection entirely, while a proof of claim prepared without knowledge of bankruptcy law or the rules that apply to claims might guarantee that you face an expensive proceeding where you have to defend your claim. Also, if your litigation includes a claim against the debtor for money or property, you should obtain the advice of a bankruptcy attorney to determine if you should file a second lawsuit in the bankruptcy court to request that the judgment you'll eventually obtain in the main litigation is not discharged by the bankruptcy case. Certain judgments can be accepted from the bankruptcy discharge, meaning that they will survive bankruptcy and remain collectible even if the debtor was unable to pay any distribution to creditors in the bankruptcy case. Examples are judgments for fraud, orders allowing fees and expenses responding to a frivolous lawsuit, or a judgment that covers a willful and malicious injury, which is a definition that could be the subject of another entire webinar. But if you are suing a defendant for fraud, for example, and expect to prevail, but the defendant files a bankruptcy petition and appears unlikely to pay all unsecured claims in full, then you're likely to want to file a non-dischargeability lawsuit to ask the bankruptcy court to confirm that your judgment will qualify under Section 523 of the Bankruptcy Code and remain enforceable post-bankruptcy, unless you're prepared to accept that your judgment may be worthless. And the deadline for such a lawsuit in most cases will be 60 days after the first meeting of creditors, meaning the complaint is likely to be due roughly 90 days after the petition is filed. Now, issues of non-dischargeability may give you one more reason to consider removing your underlying litigation to the bankruptcy court, as it may be useful and cost-effective to have the bankruptcy judge preside over both the fraud claims themselves and the issue of non-dischargeability, so that there are no questions later on about the nature of the claims that were litigated in state court, which itself could lead to more expensive ongoing proceedings in bankruptcy court. At the very least, it would be advisable to have a bankruptcy attorney involved in your state court proceedings to maximize the language in state court orders and judgments so that they are more likely to be deemed non-dischargeable in bankruptcy. For example, if you obtain an award of fees and expenses responding to frivolous litigation, it would be helpful to have language in the state court's findings that confirm that the action was frivolous, that it was not filed for a proper purpose, the debtor's actions in the state court damaged your client by increasing unnecessary fees and expenses, and that it was or should have been apparent to the debtor throughout the litigation that the result, if not intent of the litigation, would be increased costs and burdens on your client. Now, that language may be farther than a court is willing to go, but the closer you can get to the language of the standards that apply in the bankruptcy court non-dischargeability action, the cheaper and simpler the non-dischargeability action will be, perhaps even resolved in a brief summary judgment motion. But if the two actions can be joined in front of the same bankruptcy judge, the process may be simplified even further because the same judge who rules on the underlying claim can easily determine if those claims satisfy the standards for non-dischargeability. If you haven't done those first two steps to protect your potential judgment, the proof of claim and the non-dischargeability action, and the debtor is your only defendant, there may be no point in continuing the litigation in either form. Assuming you do protect your claim and either remove the litigation to bankruptcy court or choose to not contest the debtor's removal of the action, then it may also be advisable to keep that same bankruptcy attorney fully involved in the litigation as part of your bankruptcy team. Bankruptcy is a litigation-intensive practice, though more motion practice than trial practice. but your bankruptcy attorney likely has a familiarity with the rules that will apply to your litigation. And the bankruptcy community is also a very small community. In the same way that a bankruptcy judge will have the opportunity to become familiar with the debtor before trial, the bankruptcy judge is likely already familiar with the bankruptcy attorney you engage, or at least with their firm, and vice versa. Here in the Central District of California, there are only 29 bankruptcy judges compared to 431 state court judges in the Los Angeles Superior Court. And just as the judges may respond better to an attorney they've learned to trust in past cases, that attorney is likely to know the personal practices of that judge. The underlying point is that while the existence of the bankruptcy case and the proceedings related to preserving your rights in bankruptcy will add a new layer of costs to the case, that's the case whether or not your underlying lawsuit is removed. Obtaining the assistance of a bankruptcy attorney might allow you to navigate through bankruptcy court and reduce the overall costs in the litigation by helping you analyze all of these considerations to make the right decision for your client, whether you should have your case heard in bankruptcy court or in state court. Next, I want to address subpoena and witness issue. It relates to compelling testimony of witnesses at trial. It's a brief issue, but it's one that could apply to certain cases. If there is a key witness who you want to have compelled to testify at trial who doesn't happen to live in the area. Federal Rule of Civil Procedure 45 provides that a trial subpoena cannot command a party or party officer to travel more than 100 miles to testify at court unless it's 100 miles from where they reside or where they're employed or regularly conduct business. By contrast, CCP 1989 provides that a witness cannot be compelled to appear in a court that is not in the state where they're a resident. If your trial's in Rhode Island, there may be little practical difference between these two rules. But in a state the size of California, the 100-mile federal limit does not reach much throughout the state. But the state rule is based upon residence, and the federal rule also reaches the location of the witness's employment or where they regularly conduct business. So, for example, if your key witness is a resident of New York but works regularly in Los Angeles, a federal forum might ensure that you can subpoena that witness to testify at trial. Finally, if you're going to remove, there are certain deadlines that you need to know. The decision of which forum should host your litigation is a decision that has to be made with awareness of deadlines that creep up relatively quickly. If your litigation is not removed by the debtor and you're considering the possibility of removing the litigation, your time limit to make that decision is set by Federal Rule of Bankruptcy Procedure 9027, which establishes the time limit for removal as the later of 90 days after the petition date, 30 days after entry of an order granting relief from the automatic stay, or 30 days after appointment of a trustee in a Chapter 11 case, as long as that's not later than 180 days after the order for relief. In most cases, the deadline that applies is the 90-day deadline after the petition date. That usually gives you time to appear at the first meeting of creditors in the bankruptcy case and learn something about the prospects of the debtor's reorganization, or whether it's a no-asset liquidation, and even investigate assets that the debtor might be hiding. It's an opportunity to learn more about the extent of other unpaid creditors, whether there is contested litigation outstanding, and other information that might be useful to your decision, such as who your bankruptcy judge is, whether they've published opinions related to your issues. But this 90-day deadline runs parallel to the deadline for the filing of a non-dischargeability complaint, which, as I mentioned earlier, is 60 days after the first creditors' meetings and usually works out to about 90 days on average. So these two deadlines need to be considered in tandem. It would not help to wait 90 days to analyze whether or not you want to remove a state court fraud litigation that the debtor hasn't already removed, and then make the last-minute decision to remove the case only to discover that you missed your opportunity to file a non-dischargeability action by a few days. I've received too many phone calls from former clients who reach out to me a few months after their defendant has filed bankruptcy, only to learn from me that they've already missed their opportunity to remove the case to bankruptcy court or seek an exception of discharge, or both. By their delay alone, they've made the claims against the debtor worthless. So in summary, those are the primary issues that I think any state court litigator should be considering immediately upon discovering that one of their opponents in litigation has filed a bankruptcy case, in order to ensure that they're protecting the rights of their clients in a cost-effective manner and maximizing the tactical advantages of their forum. Thank you very much for listening. Have a nice day.